Good day to you. I'm Dr. Karen Melissa Durham. This is the first video in a series designed to highlight what we consider to be the most important changes to sectional title scheme management. Let's start by looking at the important changes to the Sectional Title Schemes Management Act 8 of 2011. Please bear in mind that this is not a description on all things that apply to sectional title scheme management, but only that what we consider to be the most important changes. The Sectional Title Schemes Management Act came into operation on the 7th of October 2016. The Act removed most of the scheme management and administration provisions from the Sectional Titles Act and set them out in a different order and with significant amendments. The functions of the body corporate are set out in Section 3. Schemes must have separate administrative and reserve funds. The reserve fund must be reasonably sufficient to cover the cost of future maintenance and repair to common property with a prescribed minimum. A body corporate can recover outstanding contributions or levies by application to the Community Schemes Service or the CSOS. Section 4 deals with the powers of the body corporate. Special resolutions are now required for dealings with units, for example, to purchase, acquire, take or give transfer, mortgage, sell, hire or let units. Also the borrowing of money, with the additional requirement that it must be required in the performance of its functions or the exercise of its powers. And then also leasing portions of the common property in terms of short-term lease, which is basically a lease for less than 10 years. Section 6 deals with meetings of body corporate. A fundamental change is that a person must not act as a proxy for more than 2 members. There is now a prescribed proxy form, which is Form C. When votes are calculated in number, each member has 1 vote. Take note that under the prescribed management rules, ordinary resolutions are calculated in value. Unanimous resolutions are suspended if they have an unfairly adverse effect on any member, and a member does not agree within 7 days. Bodies corporate and owners can approach the CSOS if they are unable to obtain a special or a unanimous resolution. It used to be that only the body corporate could approach the High Court when it was unable to obtain only a unanimous resolution. Section 10 deals with rules. Rule changes must be lodged, examined and approved by the CSOS. Body corporates must keep their rules, make them available at meetings and deliver them to owners as well as occupiers. Section 13 deals with the duties of owners and provides that an owner must notify the body corporate of any change of ownership or occupancy and of any mortgage. Finally, Section 16 deals with the appointment of administrators. A wider range of persons can apply to a magistrate's court to appoint, replace or remove an administrator. Administrators must be suitably qualified and independent. There are specified criteria for their appointment, which must be for a fixed period of time, and they must address scheme issues promptly, convene scheme meetings, and lodge reports with the CSOS. Meeting and reporting requirements apply to existing administrators too. Let's now take a look at the regulations made under the Sectional Title Schemes Management Act. Regulation 1 contains some of the new definitions. Managing agent is anyone who provides scheme management services for any type of reward. Scheme management services are financial, secretarial, administrative, or any other service. A primary section is designed to be used for human occupation as a residence, office, shop, factory, for any other type of use allowed in terms of local municipal bylaws, while a utility section is designed to be used as an accessory to a primary section, such as a bathroom, toilet, storeroom, workshop, shed, servants' quarters, parking garage, parking bay, or any other utility area. Regulation 2 sets up the minimum reserve amounts. There is no prescribed minimum reserve fund budget for the body corporate's first financial year, and also in circumstances where the reserve fund balance at the end of the financial year equals or exceeds the previous year's administrative fund levies. Where the reserve fund balance or financial year end is less than 25% of the previous year's administrative fund levies, then members must budget for reserves of at least 15% of the amount budgeted for operational expenses. Where the reserve fund balance at financial year end is between 25% and 100% of last year's administrative fund levies, then members must budget for reserves at least the same amount budgeted at the administrative budget for repairs and maintenance. Regulation 5 deals with the prescribed notice forms. Form A is the body corporate notification of its service address. Form B is the body corporate notification of amendment of rules. Form C is a notification by a member to a body corporate of the appointment of a proxy. There is also a complaint form to declare a dispute. Regulation 6 deals with the rules and states that rules must be considered to be and interpreted as laws made by and for the body corporate of that scheme. Let me conclude with some information on Paddocks. Paddocks is a specialist sectional title and HOA firm. We offer online training courses and workshops. We also provide consulting services and sell a range of books and publications. Thank you for watching this video. If you have any questions or would like to find out more about any of the services we offer, you can contact us or at the email that we have listed on this slide.